Welcome to IP Concerns Deep Dive, the podcast version of our IP Concerns blog from Cascade Law Group. Here, we unpack intellectual property-related, real business and brand protection topics in a way that actually makes sense, no legal experience required.
Welcome back to the Deep Dive. So, I want to start today by looking at a concept that I think you, the listener, and honestly all of us, usually just take for granted. Because we all know the famous names in American history.
Yeah.
Right? The people who built the railroads, the light bulbs, the cars. We call them the titans of industry.
Right, the inventors.
Exactly. But when you really look at the history books, there's a distinction that often gets missed.
Yeah.
There's a big difference between the person who actually built the thing and the person who legally owned the idea.
That is a massive distinction.
Yeah.
And usually, history focuses on the physical invention. We look at the object itself. We rarely look at the legal framework, the paperwork that decided who actually got rich from that object.
Right. And that is exactly what we're getting into today. We're looking at a really fascinating stack of research centered on a document titled Legacy and Law, African-American Intellectual Property Innovation.
It's a great source.
It is. But I have to be completely honest with you. When I first saw that title, I thought this might be just a bit dry.
Oh, sure.
Patent law isn't exactly my go-to beach read.
It doesn't really sound like a thriller on the surface, does it?
No, it really doesn't. But once I actually started reading the notes and getting into the source material, I realized this isn't really about law at all. It's about survival.
Yes.
It's about people using a legal system that, at the time, often didn't even recognize them as human beings, and using it to carve out a space for economic freedom. Which, the story about the origins of dry cleaning alone completely blew my mind.
That's the perfect framing for this. Because we are looking at Black History Month, but not through the usual lens that you might be used to.
Right, not the civil rights marches or the political speeches.
Exactly. We are looking at it strictly through intellectual property, or IP. We're talking about patents, copyrights, and trademarks.
Yeah.
And the central argument of this source material is that for Black creators, IP wasn't just a business tool. It was a shield.
A shield against a society that was actively trying to strip them of literally everything else.
Yeah.
So let's get into the timeline here.
Let's do it.
Because I was actually really surprised by how far back this goes. I kind of assumed we'd be starting in the 20th century, maybe around the Harlem Renaissance.
Oh, no, much further.
Yeah, the source material takes us back way further than that.
We need to go back to the early 19th century.
Yeah.
And we really have to set the scene for you to understand the stakes. In the early 1800s, the vast majority of Black people in America were enslaved.
Right.
Legally, they were considered property.
Which creates a massive legal paradox right out of the gate.
It does.
Because if you are legally considered property, how on earth can you own property, specifically intellectual property?
That is the big question. And for a very long time, the answer from the government was simply, you can't.
Wow.
There was actually a ruling by the U.S. Attorney General in 1858 that explicitly stated inventions by enslaved people could not be patented, not by the enslaved person, and not even by their master.
Wait, not even by the master?
No. The logic was that a slave isn't a citizen, so they can't enter a contract with the government to get the patent.
Okay.
And the master couldn't patent it because he didn't actually invent it. To get a patent, you have to swear a legal oath of inventorship.
So the ideas were just, floating in legal limbo?
Effectively, yes. They were in the public domain the very moment they were created.
So anyone could just steal them?
Anyone could steal them and profit from them. But there were exceptions for free Black Americans. And that brings us to 1821.
Yes, 1821. This is the story of Thomas L. Jennings.
Thomas L. Jennings. He was a freeborn Black man living in New York City, and he was a tailor by trade.
But he wasn't just, sewing buttons and hemming pants. He was obsessed with the problem of cleaning delicate fabrics.
Right, because you couldn't just wash a nice wool suit in a tub of water back then. It would completely ruin it.
So he invents a solution. The source calls it dry scouring.
Which is the direct chemical ancestor of the modern dry cleaning process we use today.
That is so cool.
Now, because he was a free citizen, he was legally able to apply for a patent. And in 1821, he became the very first Black American to receive one.
Okay, so he gets the piece of paper. He gets the official patent number. I think it was 3306X.
Yep.
But here is the part that really stood out to me in the research. And I want you listening to really think about this. It's what he did with the money.
This is crucial.
Because usually when we talk about famous inventors, the story is always they got the patent, they got rich, and they built a giant mansion.
Jennings had a completely different priority. He used the profits from his exclusive rights to dry scouring to purchase his own family's freedom.
That is it's heavy to wrap your head around.
It really is.
He used the profits from his intellectual property, the creation of his mind, to buy the physical property rights of his own wife and children.
Exactly. He used the master's tools, property law, to dismantle the master's house, at least for his own family.
That is incredible.
And he didn't stop there. He actually funded abolitionist causes and set up legal defense funds for other Black Americans. This establishes a clear pattern that we see throughout all the source material. IP isn't just about getting rich for these innovators. It's about generating the capital needed for basic survival and social resistance.
So Jennings breaks the seal in 1821, but as we move forward in time into the Industrial Revolution, the stakes get much higher.
Much higher. The machinery gets bigger.
And the resistance to Black ownership gets significantly more intense. I want to talk about the man they called the Black Edison.
Granville T. Woods. He is such a fascinating figure.
I read in the notes that he held over 50 patents.
Yes.
And we aren't talking about small kitchen gadgets here. He was working on things like the induction telegraph system.
Basically allowing moving trains to communicate with the stations.
Right, which was critical safety infrastructure.
Absolutely critical. Before his invention, if a train was moving on the tracks, it was a total communications blackout. You just had to hope the track was clear. Woods fixed that.
But his story also really highlights the dark side of the patent system at the time. The source talks about something called interference.
Ugh.
Ah, yes. Patent interference.
I saw that term in the notes, and I wasn't totally sure what it meant in practice. What exactly is a patent interference?
It's essentially a legal challenge. Basically, you file your patent, and someone else, very often a massive, powerful competitor, steps in and says, no, I actually invented that first.
Oh, I see.
It triggers this huge legal battle to prove who the true originator was.
Yeah.
Woods was sued repeatedly by Thomas Edison's company and other major corporations, claiming ownership of his ideas.
So even if you are an absolute genius, if you don't have the huge piles of money required to fight these legal battles, you just lose your invention.
Precisely. And that was a very common tactic used against Black inventors. It wasn't just about having the brilliant idea. It was about having the financial resources to defend it in a courtroom.
Which is incredibly unfair. Woods actually won many of these battles, which is a huge testament to his meticulous documentation and his legal team, but it completely drained his resources.
It sounds utterly exhausting.
Yeah.
You basically have to be a world-class inventor and a world-class litigator at the exact same time.
That's exactly the reality of it. And we see a similar kind of, I guess, strategic defensive thinking with Garrett Morgan.
The traffic light guy.
Yes, the inventor of the three-position traffic signal. But he also invented the gas mask, or what was called the safety hood back then.
Right. And the source mentioned a detail about Morgan that I found really strategic, but also just kind of deeply sad.
About how he sold it.
Yeah. He used to hire white actors to pretend to be him.
He did. When he was trying to sell this life-saving safety hood to fire departments in the Jim Crow South, he knew exactly what he was up against.
Yeah.
He knew that if he, a Black man, showed up to demonstrate this highly technical equipment, they simply wouldn't buy it from him.
So what did he do?
He hired a white man to pose as Garrett Morgan, the inventor. And Morgan himself would dress up as a janitor or an assistant, and he would be the one to actually put on the mask and demonstrate the device during the pitch.
That is just wild.
Yeah.
He had to literally erase himself from his own narrative, from his own genius, just to get his life-saving technology out into the market.
It really shows the pragmatic hurdles they faced. He had the patent, he had the absolute legal right to the invention, but the social prejudice was a massive barrier to the market itself.
He had to navigate around the racism just to do business.
Exactly.
So we have this history of patents. It's industrial, it's mechanical, it's very tangible stuff. But the source material shifts gears pretty heavily as we get into the 20th century.
It does. We move from the hardware of America to the software.
The culture.
Exactly. Specifically music.
And this is where the conversation often gets really emotional for people because we're talking about copyright.
Copyright is a whole different beast.
And the narrative here feels totally different. With Jennings and Woods, we saw them successfully using the legal system, even if it was incredibly hard.
Right.
But with music, with genres like jazz, blues, R&B. The source describes the situation much more as a historical injustice.
It was systemic theft. There's no other word for it.
Yeah.
But I think we need to be really specific for the listener about how that theft actually happened, because it wasn't usually someone breaking into a house and stealing physical audio tapes.
Right. It was all on paper.
It was buried deep in the contracts. And to understand this, you really have to understand how music law works. A single song actually has two separate copyrights.
Okay, I think a lot of people don't know this. Break that down for us. 2 copyrights for one song.
Yes. So first, there is the musical composition. That is the actual lyrics and the underlying melody.
The sheet music, basically.
Exactly. And ideally, this belongs to the songwriter.
Okay.
Second, there is the sound recording, which in the industry is often called the master. That is the specific audio performance captured on the tape in the studio on that given day.
So if I write a song in my bedroom, and then I go to a studio and record it, I own both of those copyrights.
In theory, yes, you should. But historically, the business model of the recording industry was incredibly predatory.
How's
Well, black artists, particularly in the early blues and rock and roll era, would be brought into a studio and paid a single flat fee, maybe $50 or $100 to record a session.
Which was probably decent money for a day's work back then.
It was survival money. But in exchange for that cash up front, they signed away the master rights to the record label forever.
So they got paid for the day's labor, but they lost the asset entirely.
Exactly. And it gets worse. Often because these contracts were filled with legal jargon, they didn't understand that they were also signing away the publishing rights, the composition.
Oh, man.
So the record label ended up owning the recording and the song itself. So when that song became a massive global hit and sold 1 million copies, the label kept all the royalties. The artist got absolutely nothing beyond that initial $50.
That explains so much. It explains why you hear those tragic, heartbreaking stories of legendary musicians dying completely penniless while their songs are still playing in huge movies and TV commercials. It's not just that they had bad luck or spent all their money. It was a bad contract from day one.
It was a business model fundamentally built on information asymmetry. The labels knew the massive long-term value of copyright. The artists, who were often denied access to basic legal education or fair representation, did not.
They were just looking to feed their families that week.
Exactly. But as the source indicates, this is changing. We are seeing a massive shift in the modern era.
A huge shift. You look at modern hip-hop and R&B, and the conversation among the artists is completely different now.
It is all about ownership today.
Yeah, you have artists like Jay-Z or Prince before he passed, or even tons of independent artists today who make owning their masters their primary business goal.
It's almost like the business knowledge finally caught up to the raw talent.
It really did.
And you see it in how estates are managed now. The source really touches on this important idea of generational wealth. When a black artist retains their publishing rights, that royalty check doesn't just stop when they die. It goes to their children. It becomes a permanent family asset, just like owning a house or a stock portfolio.
So copyright completely transforms from a tool of exploitation into a tool of legacy.
Precisely. It allows the actual creator to keep earning from the culture that they helped build.
That's a huge shift in power. I want to touch on the third pillar we have here. So we've done patents and we've done copyrights.
Right.
But there's one more that I think is becoming even more visible today, especially with the explosion of social media and online entrepreneurship. Trademarks.
Trademarks are really interesting because they protect identity.
Okay, expand on that a bit.
Well, a patent is for a specific thing you make. A copyright is for a creative thing you express.
Right.
But a trademark is for who you are. It's your brand, your name, your logo.
Got it. And the source explicitly links this idea of trademarks to trust. Why is the concept of trust so important in this specific context?
Think about the long history of products that are marketed to Black consumers in America. For a really long time, those products were often inferior quality, or they were sold by huge companies that didn't actually care about or invest in the community.
Right, they just wanted the demographics money.
Exactly. So when genuinely Black-owned businesses started to rise up and gain traction in hair care, in beauty, in food, the Black-owned label became a vital signal to the consumer. It signaled quality and it signaled safety.
It essentially means this was made by us for us.
Exactly. But that reputation, that trust, is incredibly valuable. And in business, if something is valuable, other people will inevitably try to copy it.
Right.
We see this all the time today, where massive multinational corporations will launch a brand that is designed to look exactly like it's a small community-based Black business.
But it's actually owned by a giant conglomerate.
Yes.
And that is exactly where the trademark comes in to save the day.
It is the legal fence. It stops the genericization of the culture. It allows a true business owner to stand up and say, no, you cannot use that name. You cannot use that specific logo or color scheme.
It protects the consumer from being tricked into buying a fake, but it also protects the actual entrepreneur's market share.
Exactly.
But, and I have to ask this, is there a major barrier here too? Because I imagine filing for trademarks and defending them in court isn't exactly free.
It is definitely not free. And that brings us right to the section of the research that talks about the gap.
The innovation gap.
Yes, because while we have all these amazing historical success stories and we see modern artists taking control, the aggregate data is still pretty worrying. The source points out that Black creators are still significantly underrepresented in patent filings and overall IP ownership statistics.
And we really have to ask why that is.
Yeah.
Because it is clearly not a lack of ideas. We know that for a fact.
No, it's a resource issue at its core. Defending a trademark or filing a robust patent application costs thousands, sometimes tens of thousands of dollars. If you don't have that classic friends and family seed round of funding that so many Silicon Valley startups just automatically rely on, you might literally never be able to file the paperwork.
And if you don't file the paperwork, you don't legally own the idea.
Yeah.
And if you don't own the idea, you can't get the venture capital funding to grow it. It's just a vicious cycle.
It is a totally vicious cycle.
Uh-huh.
And the source also mentions another major barrier, which they call the exposure gap.
What's that?
Well, if you grow up in a community or a neighborhood where absolutely no one has a patent, you might not even know that it's a viable career path.
Oh, that makes total sense.
You might be a genius who solves a complex problem in your garage, you fix the engine or build a new tool, and you never once realize, hey, I could actually own the exclusive rights to this solution.
So what is the ultimate cost of this? And I don't mean just to those specific individuals who miss out, but to us, to you listening right now.
It's massive. Economists actually have a specific term for this phenomenon. They call it the lost Einsteins.
The lost Einstein.
Yes. The idea is that there are millions of people out there who genuinely could have been the next Albert Einstein or Thomas Edison, but they were born into demographics or zip codes where they simply couldn't access the innovation pipeline.
That is a staggering thought.
It really puts it in perspective.
We aren't just talking about social fairness here. We're talking about lost GDP.
Yeah.
We're talking about actual cures for diseases that haven't been found yet, simply because the person who would have found them didn't have the legal or financial support to pursue the research.
Exactly. Innovation as a whole thrives on volume. You need as many shots on goal as possible to get the big breakthroughs.
Right.
When systemic barriers, whether it's the high costs, the lack of education, or historical bias, block a huge segment of the population from participating in the IP system, we all suffer for it.
The economy is smaller.
The economy is smaller, and technology advances much slower than it should.
But I do want to point out that the source does end with some real forward momentum. It's not all doom and gloom.
No, not at all. There are very real solutions being implemented right now.
Like what?
For example, the USPTO, the United States Patent and Trademark Office, has launched specific initiatives designed to reach underrepresented groups.
Getting the education out there.
Exactly. And there are also numerous pro bono legal clinics popping up at law schools across the country that are helping low-income inventors file their patents completely for free.
So the traditional gatekeepers are actually starting to open the gates a bit wider.
Slowly, but yes. The awareness is definitely there now. The cultural conversation has finally moved from just let's celebrate the brilliant invention to let's secure the financial asset.
It really reframes how I think about Black History Month as a whole.
How so?
Well, it's usually so focused on looking back at the past, but this IP angle, this focus on ownership and generational wealth, this is entirely about building the future.
It is about building the economic architecture of the future. It's recognizing that civil rights inherently includes property rights. The right to legally own the fruit of your own mind is a fundamental human right.
I love that. Let's do a quick recap of the journey we've been on today, because it has been a really wide arc through history.
It really has.
We started way back with Thomas Jennings, literally scrubbing clothes and inventing a new chemical process to buy his own family's freedom in 1821. Then we looked at the fierce industrial battles of Woods and Morgan, fighting off massive corporate lawsuits and deep prejudice just to help build the modern infrastructure we use today.
And then we saw that crucial shift in music, moving from the brutal exploitation of those flat-fee recording sessions to the modern empowerment of artists finally owning their own masters.
And we looked at how trademarks are being used right now to protect the identity and the trust of modern Black-owned businesses.
Yes. And finally, we look at the very real cost of the innovation gap, the steep price that all of society pays when access to legal ownership isn't equal.
It's basically a journey from just getting by to finally taking control.
That's a great way to put it.
I want to leave you, the listener, with a final thought to really chew on after you finish this deep dive. Because we often think of innovation as just a spark of genius, right? A light bulb moment in the middle of the night.
Right.
But today's deep dive shows us that the spark is really only the beginning of the story. The real game, the part that actually changes history, is the protection of that spark.
The paperwork really matters.
The paperwork matters.
Yeah.
So here's the question for you. If we all accept that the next world-changing idea could come from anyone, anywhere, what are we doing to make sure that when that amazing idea strikes, the creator actually has the shield they need to survive and share it with the world? What brilliant invention are you and I missing out on right now simply because the inventor couldn't afford the lawyer?
That is the exact question we should all be asking ourselves.
Thanks for diving deep with us today. We'll catch you on the next one.